Ladies and gentlemen, it's now time for our second panel discussion. The topic is what is needed for a common definition of court, and I would like to welcome once again Mrs. Lurger from the University of Graz, Mr. Andreas Stein, he's head of unit responsible for civil justice policy at the European Commission, and Mrs. Hana Hoblaj, she's a notary candidate from Canada. Please take a seat. Croatia. Sorry. You should never turn around and mention a country. You lose your concentration. I'm sorry. I apologize. I'm sorry. Mrs. Lurger, I would like to start with you because it's one of the main pillars of this project. Why is a uniform definition of court so important?
Thank you very much. The main arguments I already showed on the slides. As you saw, the people are really burdened with the situation which the people concerned, like the parties in a succession proceeding or the party in any other proceeding. And there is also insecurity for the practitioners who don't know how to handle this. And the advantage of our uniform definition would be that you can, in a systematic manner, include non-contentious proceedings who reach a certain standard. And this would make the handling of these really complicated, even so important conflicts regulation of the EU much easier. And it would stop unequal treatment in certain situations where it's hard to be justified. And it would also improve the situation in succession regulations. Because here you really have, the regulation wants to concentrate the proceeding in one country. And if you have a notarial proceeding which is gone through, but which does not fulfill the requirements of track 1, then there is no concentration because there is no international jurisdiction. And in this case, you have two parallel proceedings or even more, and the regulation cannot act against it. So this would very much improve this problem with the succession regulation.
Mr. Stein, we heard about the advantages of a uniform term for a court. What is the Commission's point of view?
Thank you, and a very good afternoon to everyone. Also, just from my side, to thank you for the organization of this event and for the invitation. It's a pleasure to be here. I would also specifically thank the authors of the study for the work invested, and I've read parts of it. I haven't been able to read the whole 200 pages, but I think I can say already at this stage that this is a very valuable piece of research that will feed into future exercises, and we have, of course, work coming up. We're routinely reviewing our instruments. It's not an easy exercise. It's an oil tanker that you have to move. Sometimes there is a heavy preparation procedure, but we are currently preparing a review of the Brussels 1A regulation, and we're, of course, looking at the notion of court because there has been case law specifically on the Brussels 1A regulation. For the Brussels 2B regulation, we have just reviewed it, and so it's going to be a while until it comes up again. But again, I think this is very valuable material. From the viewpoint of a practitioner, and also from an academic perspective, although I'm not an academic myself, I think it doesn't take much of conviction, as far as I'm concerned, to say it would be much better if we had a uniform interpretation or a uniform definition of what a court is across our instruments, because there seems to be very little reason why you should have divergent understandings, whether you're in the area of succession, divorce, or commercial proceedings. But having been in the negotiations, I can tell you that this is a very tough objective to achieve. And I will just tell you from the most recent experience, which was the negotiations of the Brussels 2B regulation. And for that regulation, there was a very strong impetus to do something about this, because there had been a development in real life on the ground of promoting extrajudicial divorces, be it on a consensual basis, be it with the involvement of notaries, lawyers, sometimes other legal professions. And of course, if your definitions don't capture the reality, then certain decisions may not circulate. And so member states were very intent, especially those who had adopted legislation on extrajudicial divorces, that this will be covered by the new Brussels 2B regulation. And in those discussions, we did discuss very intensely the definition of court, and we had all those models on the table. We had the successions regulation, which I think is the most sophisticated definition of court that we have in the acquis to this date, and that's probably also because I think it's the inspiration for the definition that was proposed in the study to a very large extent. And when the question came up, we did use that as a source of inspiration from our side, from the Commission side. But when you look at the final result of what's in the text of the regulation, in a way, it couldn't be much further from what we have in the successions regulation, because it's not a sophisticated definition. I think apart from the possibility of having no definition at all, as in the Brussels 1A regulation, this is the broadest and least clear definition that you could possibly think of, because it just says a court is any authority that exercises jurisdictions in the matters that are governed by this regulation, which makes everything hinge on the question, what does exercise jurisdiction means? And that's not a clear notion. So this is just to say that with all the sympathy for the quest for a uniform definition, it's just a fact of life that this will be discussed differently for every instrument, and it'll be a tough objective to achieve, to arrive at a uniform definition.
And despite the fact that it's hard to achieve, Mr. Lurger offered a very concrete definition of the court. Do you see a chance, or is that something that could be considered in this or a similar form in EU legislation in the near future?
Well, obviously, as I said, we will look at this as at any other academic and other work, and we carry out a study before every review of a regulation. And as I said, we'll prepare this for Brussels 1A at the moment, and then we'll see how far we get. I would have a few discussion points, because I think the one issue to my taste where the proposed definition departs from what we have in the successions regulation is that there is no specific reference to exercising judicial functions. And to me, but this is just my personal view, this is not the view of the Commission as an institution, I think if you want to say if there is an equality of function and there's an equality of quality, basically there should be also an equality of treatment of the definitions, then it would seem to be logical to say, well, courts by definition exercise judicial functions. If something else is to qualify as a court, they should also exercise judicial functions. And in the successions regulation, there is an alternative of acting under a judicial delegation of judicial powers and so on and so forth. So to me, sort of starting the discussion, there would be a question mark as to whether it is good to drop that reference to exercising judicial functions.
Of course, you have to answer.
I think the same function, or the judicial function, is in the last sentence of the definition. It says it has this decision with the same force and effect as a court definition, so as a court decision. So we have it. We have this decision in the last sentence. And to reproduce it once again in this other part where you need a link to the court, I think this is a problematic thing which hindered a uniform interpretation for succession proceedings in the EU at the moment. So we really think that this specific link to the court, which has to be existent, is not appropriate. It's too narrow. And but we have this jurisdiction decision function in the last sentence anyway, so we don't see the need to repeat this.
Mrs. Hoblaj, I want to bring you into the discussion. You are from Croatia, yeah? You're from Croatia. Please tell us about the role of court commissioners in Croatia as a start.
Thank you for the question. Notaries in Croatia are acting as court commissioners in succession cases and also in enforcement cases based on trustworthy document. So Croatian notaries are dealing with succession cases since 2003 and very successfully. But only where there is no dispute between the heirs, so non-contentious cases. And the goal of transferring the competences from the court to the notaries was to unburden the judges. Now notaries in Croatia are fully independent when making a decision in succession cases and also in enforcement cases. And the decision made by the notaries are final and doesn't need any confirmation by the court. So court cannot give any instructions how to make a decision. But as I said, this is only when there is no dispute. If there is dispute or if heir or the party files an appeal, then notary will send the case back to the court and court will proceed.
Yeah. Can you tell us a little bit about the famous Pula parking cases and how it's and the reasons
Yes.
it influenced a lot of things?
Yes. So the role of notaries as in enforcement cases was discussed by the European Court of Justice in Pula Parking and Zulfi Karpasic cases, and also some other cases, but these are most famous.
Famous for it.
Yes. So the court decided that when Croatian notaries were acting in enforcement cases are not equally to the court because they do not meet all the requirements which are prescribed by the regulation Brussels 1 bis. And also, sadly, we are not expressly included in Article 3 of Brussels 1 bis like Hungarian notaries. So our government decided to change the enforcement law, and now in 2020, we became court commissioners also in enforcement cases, but only when the debtor has a residence in Croatia or seat in Croatia. So this is a new, so we evolved from the original competence to the court commissioners in enforcement cases.
Mrs. Lurger, we just heard about different tasks, but where would it be easiest to transfer tasks from court to the notaries? Succession or registers or divorces? Is there, and it's a place where it's easiest? The microphone, please.
I think there is really an emerging field which was already mentioned, which is out-of-court divorces. Mm-hmm. For many reasons, it's a very personal and intimate relationship you have in families, so even with children and also between spouses. And so you should justify where the state should intervene at all. And if it has to be done, it has to be in a very smooth manner, in a very special manner, I think. And here I think that really also in substantive law that courts are the least appropriate to do that because they're coming as an authority. They're in a public courtroom. And I think if you're especially filing for a consensual divorce, you don't need state authority in this way. And you need to, perhaps to settle dispute is one of the outstanding tasks of the state and the courts. but it's not in every family manner, and that's why we have so many family decisions in non-contentious proceedings in many member states. That is the reason, because they think there needs to be a special atmosphere of cooperation and so on, because you have to care for what is going on there. So these are very sensitive things. And here I think notaries, with their impartiality and their legal advice they are able to give, are used to give in other circumstances, and also with their experience in future provision in legal terms, what there needs to be a good future for the separated spouses. And impartiality, so you don't are not on the side of either spouses. I think this really seems to be, with all our arguments and systems analyzed, I think this is one of the really parts where we don't only need in this substantive reform in the law of many member states, and there will be such reform. I mean, Austria is a complicated case. As we all know, we have a very old, dated, fault-based system of divorce. But I think in many member states there will be changes, and of course they will all profit from the new version of process 2.
You want to expand non-contentious procedures at the European level. What would you prefer, that it's done by European legislation, or would it be enough if it's more reflected in EU justice policy instruments?
Yeah, what we saw on the legal side was that we really can't change much by interpreting the instruments we have, because the definitions are not uniform, and succession regulation is what it is, and it excludes certain notarial proceedings and so on and so on. So little can be done by court interpretation of the existing instruments. So we are really looking to the Commission and the revision processes where really our recommendations could go into. It's not the interpretation of existing laws so much. And then we are on this, but of course the Justice Core Board is needed in addition. So it's an additional instrument which improves the situation. We also need a discussion and discourse and information about other legal system, also on the national level, so that it is clear, there's clear information how the systems are formed, and you can also learn on the national level from other systems. And this all can be coordinated through the EU, because it gathers this information. So this is extremely important instrument in addition. And
Yeah, that's it.
Okay.
Mrs. Hoblaj, you spoke about the changes that have taken place in Croatia. What is the future?
Well, I'm very happy to say that just a few days ago it was adopted in Croatia a new land register law, by which Croatian notaries also will be court commissioners in procedure of renewing land register books. So we have the areas in Croatia where land register books are outdated, so they doesn't show the real situation on the ground and who are the owners and the land boundaries and so on. So this procedure will be proceeded by the notaries as court commissioners, and this is really new. So now our Croatian chamber will provide educations and lectures for the notaries, so they can proceed with that. But in future, we really hope that we will get a new non-litigation procedure law, because we have a really old one, and that by this law we could get some other competences, like in Slovenia, so the consensual divorces, or a recognition of the paternity, because we don't have this yet, or declaration of missing person as a deceased, or securing evidence, or agreement on the land boundaries, and so on. So the other non-litigation procedures.
Mr. Stein, we heard about all the wishes and the future. In the planning of the Commission, what would be the next opportunity to talk about this, to discuss all about this? And is there any follow-up possible?
Yes, of course. Let me just maybe just set out that, of course, the extent to which a member state wants to delegate certain tasks from courts to other professions, whether it's notaries or others, is a decision that has to be taken at the national level. That's the full autonomy of member states in how they organize their systems. But of course, there is a direct connection, because you're not likely to do this if you run the risk of your decisions not circulating across member states. So I think that's how the two levels have to communicate, and I think the changes in Croatian legislation after the Pula parking rulings are an example of how this plays out. So I think from the EU perspective, I think the main guideline is how to make sure that there is no undeserved distinction between different types of instruments. And I say that because I'm not, I readily acknowledge that the definition of what a court is, although being difficult, is one gateway, but it's not necessarily the only gateway by which you can tackle these things. And I will give you a concrete example, or maybe even two concrete examples, because the next exercise, as I said, is the review of the Brussels 1A regulation, which is a field in which there is no definition of a court. At the same time, it's the field in which we have seen the Pula parking decisions, and who would have ever believed that parking tickets in beautiful Croatian tourist destinations would acquire such fame in the field of private international law. But this is actually an extremely interesting case because what the judgments tell us is that the court, in principle, adopts a functional view of what a court is. There is no definition, and if you read the judgment, it's basically based on the same criteria: independence, impartiality, giving a hearing to both sides, to all parties involved. So I think this is pretty consensual. These are also things that would be in the uniform definition. And then the court comes to the conclusion that the Croatian notarial enforcement system doesn't meet these requirements. And there are two observations here. The first observation is that's true, but the Croatian system is practically identical to the Hungarian system, which was added to the regulation specifically to say, but those decisions are covered by this regulation. And the second observation is that the procedure is done in some member states by notaries, in some member states by courts, but even where it's done by courts, very often there is no hearing of the other side. So in that context, there's also a formal argument. If an entity that calls itself a court did exactly the same thing a Croatian notary does, this would be covered by Brussels 1A with no problem because it's a court, although the hearing to the other side is also not offered. And I think those are inconsistencies that we will certainly have a look at when we look at Brussels 1A again. The other example that I wanted to mention again, and also as a bit of a pointer to a possible other gateways, is the Brussels 2B regulation again, because that's the most recent example of where we have amended our legislation. And I want to come to the two things that I think were outlined in the study and by Ms. Lurger as the possible areas where you have concrete consequences. And that is, does the decision circulate as a judgment does? And do the rules on international jurisdiction apply? And I agree on that diagnosis in principle. If you look at the Brussels 2B regulation, I think it'll be very interesting to see, whether notaries will be seen as courts under the definition. I think that it's difficult to predict that. At the same time, it's not going to be so important, because if you look at the regimes for judgments as opposed to authentic instruments, and even agreements by parties that were registered with a notary, the differences on those 2 points, international jurisdiction and circulation, have been reduced or possibly even eliminated. And then it doesn't make so much of a difference anymore whether it's a court under a definition or not.
Well, I just wanted to add, because you said that if a court does something what Croatian notaries do, then it's a court decision, and in the other case not. There is also one very important example. There are examples for the very same thing under the succession regulation, because the German Erbschein, for instance, is recognized, because but it's if a notary would do this, what a German court does, it would never be a decision. So this formal side of the court notion, which we now have, with a court doing this, but being a court that's different, I think that's also against the functional notion, which has to be looked at in the succession regulation.
Mrs. Lurger, Mrs. Hoblaj, Mr. Stein, thank you, thank you, thank you. Panel number 2 has ended.